the law is such an important part of the mosaic of prevention. When I was a young boy, when I was 8 years old, somebody showed me a book about the Holocaust, and I saw some really disturbing photographs, and it had such an impact on me. I thought, how could this have happened? And what can I do to make sure that this doesn't happen again? And eventually, when I went to law school, I got interested in studying war crimes prosecution. And then I had this opportunity to work with the International Criminal Tribunal for Rwanda. So that kind of led me along the path. And it just so happened that when I arrived at the ICTR, at the Office of the Prosecutor, I was assigned to the media cases. And it was somewhat luck of the draw, and it changed my life. Because through working on those cases, I realized that speech plays such an integral part of the mass atrocity process. How is it that neighbors will turn on neighbors, friends will go against friends and commit terrible crimes? It's through speech, it's through dehumanization. And so that became my main area of interest in terms of becoming a scholar, and it's led me to this path, and this book represents the culmination of all the work that I've been doing in this area. When you talk about atrocity speech law, you have to realize that there are two aspects to it. There's atrocity and then there's speech. And I think this is an important contribution to the literature because for the first time, it's recognizing that there's a full scope of atrocity offenses and speech that can be connected. What we've been seeing in the past is people talking about incitement. Incitement is only one offense. We have other offenses that need to be considered. Instigation, ordering, persecution as a crime against humanity. Atrocity speech law takes all of those into account. And what it does is it takes the individual speech offenses, instigation, and it attaches it to all the international crimes. Incitement, same thing. All of those crimes are covered along with all of the speech offenses. And so it serves as a very important, I believe, umbrella term that allows us to understand the full scope of the law, because some of the terms that have been used for it in the past, international hate speech law, that doesn't give us a sense of its connection to mass atrocity, right? Because you could have a human rights violation related to hate speech that does not involve thousands of people being slaughtered. And international hate speech law doesn't cover it. Incitement is another one that has been used, incitement law. No, there are those other offenses that I was talking about, persecution, instigation, ordering. So atrocity speech law puts it all together, and I'm hoping what it does is it makes scholars, jurists, practitioners understand that we need to think of these offenses together and understand how they work vis-a-vis one another, and that they are connected to the worst crimes. Because this book is about how speech is integral to persecution campaigns, mass atrocity campaigns. And if we have a fragmented definition, which is what we've had, then we're going to have a fragmented approach. And that's what we've had, is a fragmented approach. And so I think what we can do with the term atrocity speech law is finally understand how we put it all together and we come up with an approach that is unified and that actually works. Look, while it's really important to regulate this kind of hate speech that leads to mass violence, it's equally important to make sure that we don't go too far and that we protect freedom of speech. And the propositions that I put forward in the book, I believe, will strike that proper balance. There is a lot of concern in the book about how we can protect free speech. For example, with respect to incitement, I talk about the fact that we should look at the speaker, the nature of the speaker's words, but the speaker's identity as well. If the speaker is a member of the minority, if the speaker is a dissenter, not part of the government, for example, we should accord that more respect in terms of free speech. If the speaker is a member of the government or a member of the majority and is using speech really as a bludgeon, as part of a campaign of persecution, for example, against a victim group, then we should accord less protection to that kind of speech. So that's part of the incitement analysis. With respect to persecution, when we talk about hate speech as a crime against humanity of persecution, I think we have to look at the specific situation on the ground. So when the speaker is issuing this hate speech, where is the speaker vis-a-vis the violence? Is it more attenuated? What's the chronology? And what's the nature of the speech? What is the medium of speech? That's another important aspect of the book. Are we talking about social media? Are we talking about print media? The radio, television? We need to distinguish between and among these different media, and I think that helps us protect free speech. The unified liability theory, I think, is one of the main contributions of the book. What it does is it tells us to look at each of the offenses that relate to speech and mass atrocity and to categorize them properly and define them properly. We've been mixing things up. We mix up incitement with instigation. Just to give you an example, incitement is speech that is anterior to or before violence occurs, but where no violence actually takes place. Instigation is speech that is before violence, but where violence actually takes place. So one of the things that I talk about in the book is the fact that because people mix up instigation with incitement, they often think that incitement has a causation requirement. It doesn't. And the book helps distinguish between those two modes of liability. And so the unified liability makes sure that everything is clear and fits together. And it also makes sure that we have complete coverage of the various ways that speech and violence can be linked. So I talked about the fact that sometimes speech comes before violence, but speech can also happen, or speech can be uttered during violence. And there have been gaps in the law. One final point about the unified liability theory. Take the crime of incitement. Right now, the way things stand, all we have on the books is incitement to commit genocide. Why is incitement limited to genocide? These other crimes that I've mentioned, crimes against humanity, war crimes, they're equally serious crimes. They're horrible crimes. And in fact, they're more practical to charge because genocide has a very high mens rea or mental element. And it's hard to prove, whereas those other crimes are easier to prove. Why can't incitement be linked to those? The unified liability theory allows for incitement to be detached from genocide exclusively and linked to the other core crimes. So it's very important in that regard too. So as I was talking about, we often think of speech in connection to mass violence as happening before the mass violence and as being a cause of the mass violence. But let me give you another scenario. What if you have mass violence that is going on and you have speakers that are essentially acting as like a chorus to encourage the violence as it's going on? I would refer to this as egging on speech. There is nothing that covers that in the current iteration of the law. There is general accomplice liability, but one of the main points that I make in the book is that speech is so crucial in terms of fomenting mass violence or human rights violations that there should be speech-specific offenses. And speech abetting is what captures that kind of speech that is synchronous with or going on at the same time as the violence, not necessarily causing the violence. If it causes the violence, then it's instigation. You see, with the unified liability theory, we can find what the speech is at issue, properly define it, and properly charge it. The other thing we can do is we can put it together into one provision in a statute. And one of the things in the book that I emphasize is that I believe we should have a treaty that will classify these speech offenses, and we should amend the Rome Statute for the International Criminal Court to have one speech provision in Article 25 bis, and that will, I think, allow prosecutors to see how these speech offenses fit together, and it will make for, I think, more logical and better charging decisions. When you think about what's going on in the world today, it's kind of becoming a scary place. And I've talked to a lot of people who feel somewhat like we're going back almost to the 1930s. And when you think about all the propaganda that was going on in the 1930s that ultimately led to World War II and a lot of the terrible crimes that led to the human rights movement in the first place and to the birth of this body of law, I think we have to be very mindful of the propaganda side of things. And this book will address, I hope, some of the speech that could be out there that in the 1930s was able to get through to the point where there was a Holocaust, there was a fascist movement in Italy and militarism in Japan, and there were things like the rape of Nanking, and there were terrible atrocities that were committed around the world as a result of speech that was percolating and not being regulated and not really being paid attention to sufficiently. We have history as a lesson that we have to learn from with respect to the way hate speech has had a huge impact on the course of these terrible crimes taking place. We can avoid that. And I think what's at stake here in this book is reminding the people who are in charge of bringing cases, who are in charge of regulating the way that speech gets out into society, that we have got to take this stuff seriously. And one of the key ways that we take it seriously is through the law. The law is such an important part of the mosaic of prevention. I've been talking a lot about the law, right? But we have to understand that there is a human dimension to all this. And one of the aspects of the book that I'd like to emphasize is that this isn't just a book about the law. This is a book that tells a story. And it tells us a very human story. It's a story of a law that formed over time, that was put together in a kind of haphazard manner according to the needs of various jurists at different times. At the time of Nuremberg, there were certain needs and there were certain historical realities that the framers had to deal with, and so they put this law together. And then that human element continued to the point where people were cutting and pasting, and we have this very disorganized state of law that this book, I think, will help us understand can be cleaned up and function more effectively. But that's one element of the human side of the story. Another element of the human side of this story are the victims. Think about it. When this speech is out there and when it's causing these terrible crimes to be committed, there are individuals whose lives are affected. And one of the most difficult parts of the book for me was to talk about some of these individuals, beginning with a story that I recount in the book of a woman who found some children, Jewish children, on the side of the road who had escaped a train that was bringing them or taking them to an extermination camp. And she brought them to their home, she fed them, she gave them some comfort and some warmth. She took them out behind her house and shot them. And later she was asked why she could do such a horrible thing. And she talked about the propaganda that she had been hearing for years that had been coming from the German state that made her feel that these children were less than human and that she had a duty to kill them. Another story that stands out that is very difficult to think about and was difficult to write about is the young girl whose father was targeted on RTLM, Radio Télévision des Mille Collines, which was the radio machete from the Rwandan genocide. And her family fled because they knew that their father was being targeted, but she loved her father so much she wanted to stay with him. And in the book, I talk about how she stuck by her father's side until the militias came and killed both of them. We have to remember that while these cases are about large numbers, that it's always really the individual that is the most important, and we can't lose sight of that. So it was difficult to write about that, but I think it's also really important for people to remember that that's what this is all about. And I think the book will make people realize that. I hope it will, and that people will react on a human level, so that if we get this law fixed properly, it's those individuals who will be helped. Their lives will be saved, and that's what this is all about.